I'm live. Okay, legal updates. Get the personal ones out of the way, I think. Right, so currently I have lodged 3 judicial reviews, or lodged for permission for judicial reviews at the High Court. That's 2 personal cases and 1 for Julian Assange. The personal cases, 1 is involving planning permission, the other involving my electricity supplier. The planning permission is for a shed I've built at the back of my garden, and also some decking at the front of my house and a little bit of a canopy. That judicial review was surprisingly struck out. I don't know what that means, except that judicial review has now gone on. I've posted it to the Court of Appeal. You see, in following the government guidance book on judicial review, it says you'll get either refusal on papers with reasons, refusal on paper and told that your case is without merit, totally without merit, or you'll get it allowed. No mention of what to do or what struck out means. I know what they want me to do. There's a separate avenue of planning permissions legislation and things you can do to appeal things on the basis of some legal point, and you have to what you call it's called by going as well. It's also called going by way of case stated, and it's understood that when you go by way of case stated, you have no ability to appeal. But that's only one reason for me not taking the planning route or even considering that way, is knowledge of that nuance. The main reason is that I'm claiming human rights abuses by my counsel, and there's no room to have those dealt with, and the correct place is through judicial review, in my opinion. I'm realizing that the High Court does everything in their power to dismiss all cases and keep the workload down and discourage continuance and keep the workload down for higher courts. Right, so that's planning. EDF, my gas supplier, went to court and got an unlawful warrant of entry to my house. They didn't. This would have permitted them to use force. They didn't have to use force. Of course, I let them in, and they didn't achieve their objectives. But nonetheless, there's 3 strict criteria to get legal criteria to get a warrant of entry. Now, I knew they didn't satisfy one in particular, and I put a written submission into the magistrate's court to say such, but they didn't want to hear it. They didn't read the submission. All they did is railroad me, steamroll over me. But it also, but it's turned out that the gas company didn't even submit evidence of any of these three things before the magistrates court. Now the magistrates court it's wrote in the law literally they have to satisfy themselves on written information, sworn written information. Yeah, it's not a little mini trial, which is what they like to conduct it as when somebody turns up, and you know, based on oral testimonies and such. Anyhow, so that's that. Now that's recently been put into the Court of Appeal. Now, lastly, the Julian Assange judicial review is actually developed into kind of two cases that are now lying with the Court of Appeal, because initially I asked for what you call interim measures of a writ of habeas corpus for Julian Assange, and that was initially ordered to be dismissed. And so I immediately filed against that order to the Court of Appeal. Subsequently, 2 weeks later, the whole judicial review request was dismissed, and that now lies with the Court of Appeal submitted. The request for habeas corpus was summarily rejected on the basis of standing. This is as I understand the law and the development, a bit of an antiquated notion, wherein there's sufficient interest. It's stated in some case law that, you know, they want to not allow any little busybody to interfere in other people's business. That's kind of an understandable concept, but the particular case that says references busybodies and such, there's a dictum by a Lord Diplock who goes on to say that in principle any single person should be able to come to the court to get wrongdoing stopped, and this is understood to give grounds to what you call public interest judicial reviews, and I clearly wrote on my application that this was on the grounds of public interest, that my government is arbitrarily, or has been, or has done, arbitrarily detained Julian Assange. So that now lies with the Court of Appeal. The gas company, so the planning, as I mentioned, was struck out as wrongly filed. Yeah, I'm not even looking at it. It should be filed somewhere else. So that's gone to the Court of Appeal, where I expect it'll be referred back, and they'll give me an oral hearing, which I expect the oral hearing will be to be dismissed, because I've had now 2 oral hearings. So it's the likelihood of getting, I've looked at the statistics, the likelihood of getting them to change their mind upon oral hearing is only like 1 in 8 chance or something, 1 in 10 chance. The gas company judicial review was refused on papers with some reasons. So I went to the oral on the 10th of May. I went to the oral hearing for that. I explained to them why those reasons were bullshit, and of course they didn't see it that way. So that now goes to the court appeal. In the Julian Assange case, at the first instance, the interim measures was given rejected on standing, to which and it was very simplistic. It just said, this case has nothing to do with you. I can't see you have got any standing whatsoever. Boom. The interim measures. Fortnight later comes the assessment on papers, and that was a first for me, dismissed totally without merit. Now that seems a bit of an absurdity, given the fact that I'm standing on a UN judgment, United Nations Working Group on Arbitrary Detention judgment, and Julian Assange's submission to that group. To simply say there's no there's no merit there, it just said, you should have just, it isn't nothing other than an attempt to discourage me. Also, in dismissing it without merit, he awarded, this is a first for me in my legal actions, he awarded costs to the government of £520, which I've wrote back to objecting. Which I don't expect them to pursue until all the appeals processes have spanned out. But I don't have it, and I'm not worried about it. You can't get stuff off somebody who ain't got nothing. The refusal on papers, dismissed with without merit. It was hardball, because he knew my position of adopting this dictum of Lord Diplock's, that any single taxpayer should be able to come to the court and get wrongdoing stopped. And he claims that I've taken this quotation out of context, and he elaborates, explaining the context of that case, but that the context has nothing to do with that sentiment expressed. Yeah, it's true. That case has nothing. It's nothing other than an attempt, again, to discourage me. So he came back with force against this notion of standing that I claim to have on public interest grounds. He awards costs, and he goes on to rabbit on about how my submission, rather coincidentally, I filed on the day Julian Assange was dragged out of the Ecuadorian embassy. So my submission was ignorant of those facts. I was ignorant of those facts until I returned home late afternoon. And he discusses how the fact that Julian Assange's position has moved on so much, he criticizes my submission for not having taken account of this. Even if, well, so my appeal is, yeah, this is a public interest. Yeah, it's the defining case. This Regina versus Inland Revenue, and plus Federation, something or other, with this Lord Diplock mandate, this Lord Diplock mandate, it's the defining case that grants permission on grounds of public interest, and not having one's government arbitrarily detain persons is of enormous public interest. So I make that case in my appeal to the appeal court. As far as the rest of the ramble that he goes on about how I've not taken account of this and that and all these subsequent events, they're actually irrelevant to the case. The charge put by the UN working group is actually a couple of years old. So the subsequent events are irrelevant to the charge. Yeah, I put it like this as well, or plan to put it like this in the appeal court. You know, if you arbitrarily detain somebody for 5 years, and then as somebody pulls you up, you start filling in the paperwork and say, "Oh no, he's being processed now through the proper legal system. He's not arbitrarily detained." That doesn't take away the 5 years of arbitrary detention. So that's that. So there's the 4 cases lying with the Court of Appeal. I'm worried a little because of the planning one. That was filed almost 2 months ago. To me, it feels like 6 months ago, and I had to check the dates. Maybe it's even a month and a half ago, but it feels like 6 months ago. But I've only just literally this week filed. Was it last Monday? In the last week, filed the gas supplier appeal. But when I submitted the initial appeal to regarding Julian Assange's wanting a writ of habeas corpus, I kind of, on the cover letter, I kind of demanded its urgent attention for obvious reasons, that I filed it urgent at the High Court with the extra paperwork of urgency. And yeah, they got back to me pretty quickly. And I'd made a mistake there, legally speaking. As I say, I'm working from the government guidance handbook and what other knowledge I pick up by reading judgments. And it outlines these clear cases where you need permission. And it's a crazy situation that all these things that now lie at the appeal court, they're lying there not as appealed. They're actually, the full documents are in, but I'm applying for permission to appeal. And having got permission to appeal, then the next stage is consideration of that appeal and whether you can appeal. I don't understand it. I mean, it's the same with this judicial review. You're not applying for judicial review, you're applying for permission to have it judicial reviewed. It's a bit nuts. Now, when I initially filed the Julian Assange materials in regards of habeas corpus, the first dismissal, it was thinking that I didn't need permission. On the forms it says, do you need permission? And the basic rule I've learned is you always need permission. But luckily the appeal court didn't throw it back at me saying, wrong, go get permission, you've not right. They've accepted the claim as, see, even if you don't get permission, you have the right to go to the appeal court and ask them for the permission to appeal. And so that's how all my cases stand now. There's some revisionary work been done early on with that case, where I'm seeking permission. That's the strange one with the planning one. I also appealed to the planning, but not realizing I was needing permission. But I expect that'll come back to me, and they'll similarly request that I sort out the application. You know, when you've got permission, there's less documentation needs to go in. When you to the appeal court, when you're applying for permission, the full bundle has to go in to them. So that's about it. Expecting now that the wheels of justice to turn slowly, and I can have a little calm before the oncoming storms, relax from the stress a little, which means I'm probably going to get the planning stuff on my laptop anytime now, just to keep the stress levels high and keep all the balls in the air. Yeah, so I did have a visit planned for Julian Assange. I got an official notification that I could have a legal visit to Julian Assange, and I got up because insane about not wanting to be late or be stressed about the time and such. I set off hours earlier than I needed to, like 4 hours early. Yeah. This meant that I got to London, 200-mile trip. I checked my email at like 9:15, only to find out that Julian Assange had cancelled my legal visit. I posted it on Facebook, and a few people jested with me that it was because he was seeing Pamela Anderson, and there may be some truth to that, but I can't afford to make that trip again without an invite, really. So there's that. Now, Julian Assange hasn't. I write to him. At first, I wrote to his so-called lawyer, Jen Robinson, the barrister QC. I don't know if she's QC or not. Doughty Street lawyers, quite a renowned group of lawyers. But speaking to, I've encountered this problem before, but you can't approach barristers directly. It's just not the done protocol. This is an antiquated quirk of the British legal system. There was a change in the law, and there is a mechanism to, in some manner, contact them directly. But yeah, it's quite clear that the law that was implemented to shake up the legal system hasn't done. So I got a note back saying that if I needed to have a legal visit with Julian Assange, that I should go through his solicitor. I didn't know who his solicitor was, so I asked them. They told me, sort of. I won't venture the name because I think there's secrecy around all this. Suffice to say, I looked up, I contacted a solicitor who I thought they told me it was. And I spoke with the receptionist and then a senior personal assistant, and I emailed her a lot of bump and correspondence, and I phoned back later. The upshot is that I got a phone call back, but I was driving, and I said, "Look, I can't speak. I'm driving." Did he go, "Okay, I'll call back later" or something? No, yabba 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 yabba. I said, "I can't hear you because I'm doing 70 mile an hour on the motorway. The tire noise." Um, I said, "I can't make out anything you're saying." I heard somebody say Assange and such and such. So, and it was a man getting back. I thought he said, "I'll ring you tomorrow," but I'm not really available on the phone. My SIM card's always in the. But I kept available that day to see if he got back. But there were other developments in the night. I'd sent him all my legal submissions, as well as during the day I'd forwarded some of the government legal department emails to them. And I thought, oh, maybe I've given them too much material. They want to review this before getting back to me. But anyhow, I'm on my own in this business with Julian Assange. If I expect that if I get an oral hearing, that it may break as a story. But other than that, well, we'll see. But from my perspective, the die is cast. There's nothing that can be done or said to stop this running its course. From my point of view, my tack has been set, and that's the way it is. And I just keep pushing. And if I get rejected at the Court of Appeal, in a way, well, it will be great if I get accepted by the Supreme Court, but I will move on the application. Now, the Supreme Court are more on what kind of things can be appealed and go to the court. But it's a funny old business, you see, going by way of case stated and not having access to an appeal. Some months ago, there was a case, and they're on YouTube's doing the summaries of the cases and the verdicts. And Lady Hale is explaining that normally this person wouldn't have been able to appeal, but we've taken the case regardless because of its interest, I guess. So just because, the key is not to be discouraged. Yeah, the knockback statistics from getting a judicial review are like 90%. When the results from appeal are like 1 in 3, so like 33% or 60%, 66% knockback. That's a big change in the statistics, and especially when you believe thoroughly you're right. I mean, no, it's not like I'm trying to bring some legal action which is got the finest nuance to it. It's clear in the Assange case that I stand on a UN judgment. It's clear in the gas case that there are these 3 things that have to be provided in evidence, and none of them was absolutely crystal clear. The planning is tricky. Yeah, the planning is tricky. I'll grant them, I'll grant that. But it's only tricky because of the complexity and how many issues have to be looked at to get the entire picture. Each of the issues is simple to my mind. So that's a little update. Hopefully it recorded okay. Toodles.